Okay, Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. Please introduce myself. My name is Ramadana Anindya Bahri. I am from the Faculty of Law, Universitas Trisakti, Jakarta, Indonesia, especially from the Procedural Law Department. And today I want to present my presentation. The title is The Legal Standing of the Criminal Confiscation Against General Confiscation based on Indonesian Bankruptcy Procedural Law. Okay, we will begin, and we're moving forward to the next slide. The contents of my presentation is from the introduction, and then research methodology, result and discussion, conclusion, and at the end is the suggestion. Okay, we are moving forward to the next slide. Okay, because the time limit of this presentation is maximum of 10 minutes, I will not read one by one per slide and point per point. I will going through the whole of the point of view, my point of view. This is the introduction. The development of Indonesia's national law aims to create a just and prosperous society based on Pancasila and the 1945 Constitution of the Republic of Indonesia. In order to realize the goal of developing national law, the formation of law is directed at the formation of statutory regulation that can encourage the realization of a national system that support the national economy. We're moving forward to the next slide. And bankruptcy is a settlement of debts through general confiscation of the assets of a debtor who is unable to carry out his obligation, the management and settlement of which is carried out by a bankruptcy receiver under the supervision of a supervisory judge. And the legal instruments for bankruptcy settlement and suspension of debt payment in Indonesia are regulated in Law Number 37 of 2000 and 2004 concerning bankruptcy and suspension of debt payment, called Indonesian Bankruptcy Law. And we going through the formulation of the problems in this research is: what is the legal standing of the criminal confiscation against general confiscation in bankruptcy? And what is the criminal confiscation mechanism in the aspect of evidentiary based on the Indonesian Bankruptcy Procedural Law? And we're moving forward to the next slide. This is the research methodology. Based on the formulation of the problem that the authors has put forward in the previous section and related to the objective to be achieved, the research method used in the normative legal research method. Normative legal research or library research is legal research that is carried out only by examining literature or secondary data without using primary data. Okay, we're moving forward to next slide. Data analysis in this study was carried out qualitatively. Qualitative analysis is data analysis that provides description in words of findings, and because it prioritizes the quality of data and not quantity. And the achievement indicators of this research are finding weakness in the bankruptcy dispute settlement mechanism and creating a modified model to reduce the weaknesses of the bankruptcy dispute resolution mechanism. Okay. We're going forward to the next slide. This is the result and discussion. The Indonesian bankruptcy law states that all confiscation that have been made will be deleted and, if necessary, the supervisory judge will order their removal. Confiscation referred to the Indonesian bankruptcy law are general confiscation, now in civil law, as joint guarantees for all creditors for payment of the debtor's civil obligation to other parties. However, apart from general confiscation as referred to the bankruptcy law, it is also known as criminal confiscation. Criminal confiscation in the Indonesian Criminal Procedural Code or Kitab Undang-Undang Hukum Acara Pidana or KUHAP is called foreclosure or penyitaan. KUHAP defines foreclosure as a series of investigative actions to take over and or keep under their control movable or immovable, tangible or intangible objects for the purposes of evidence in investigations, prosecutions, and trials. From Article 1.16 of the KUHAP. We're going forward to the next slide. This condition raises which confiscation will take precedence in confiscation. This is because both bankruptcy and criminal confiscation are in the context of providing protection for the public or other interested parties. Therefore, in order to protect existing interests both in the context of an investigation or in the context of general confiscation of bankruptcy, it is necessary to have coordination with the authorized official. Okay. The intersection between criminal confiscation and bankruptcy confiscation appears in the Article 39, paragraph 2 KUHAP, which states that objects that are confiscated due to civil cases or because of bankruptcy can also be confiscated for the purposes of investigation, prosecution, and trial criminal case, as long as it complies with the provision in the previous paragraph. Which is in Article 39, paragraph 1. We're going forward to the next slide. And the conclusion of my research are: number one, if the assets enter the bankruptcy estate based on the bankruptcy procedural law obtained by the debtor from the proceeds of the crime of money laundering, and then the same assets are also confiscated in the context of force effort as one of the stages of the law criminal procedure stipulated in the KUHAP, then from the intersection between these two procedural laws, the property will eventually be confiscated by the state. Which means, in a case model like this, the criminal procedural law will take precedence and criminal confiscation will take precedence. And the conclusion number 2, and vice versa, if the assets that have entered into a bankrupt bank for general confiscation has been carried out on them based on the bankruptcy procedural law, and the assets have been proven based on the evidence in the criminal procedural law, not as the result of a money laundering crime, and also the acquisition of this asset does not harm the state, which is State Revenue and Expenditure Budget or APBN, then the bankruptcy procedural law makes priority over these assets, and the priority is given to general confiscation treatment rather than criminal confiscation. And we will be moving forward to the next slide, suggestion section. My suggestion based on my research are: in the legal system in Indonesia, it is recommended to make a new legal product which is equivalent to the law or undang-undang, which ensures a certain standardizations, and based on this standard, it is also determined which procedural law must take precedence if there is an intersection or collision between one procedural law with another procedural law, each of which originates from a different material law. In the case of this research, if there is an intersection between the bankruptcy procedural law and the criminal law. So that is my suggestion based on my research. So thank you, ladies and gentlemen, for your attention. Good afternoon. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.